let's make a start. So good afternoon and welcome to our presentation on IR35. My name's Alison Treliving. I'm one of the employment partners here at Squire Patton Boggs, and I'm very happy to be chairing today's session. I'll hand over to two other panellists today to introduce themselves. Patrick, do you want to
hi
introduce
everyone.
yourself?
I'm Patrick Ford, a tax partner at Squires.
Good afternoon, everybody. I'm Dan Haslam. I'm Group Sales Director at Giant Group.
Thanks, guys. So the format of today's session is we have an hour. Thank you to everyone who sent questions in advance. It seems that there are still a number of questions about this topic. We talked about it a lot end of 2019, beginning of the year, and obviously with the government pulling it from coming live in April 2020, and us all focused on COVID and Brexit and all the other things going on, it's gone a little bit quiet. But judging by the number of people that have signed up today, it's a very hot topic and one that people are turning their attention to now in advance of its implementation in April 2021. Or will it be? That is the question we will tackle a little bit later on. The format for this afternoon is that we will have a presentation. Starting off with Patrick, I will say a few words, and then Daniel. And then we will have a amount of time at the end of the session for Q&A, because people do have some questions. So if you do have any questions as we go through the session, then please put them on the Q&A section of the webinar, and we'll try to get through as many of those as we can at the end. As I say, we've allocated a good amount of time for that, because I know that's where a lot of the interesting points come out and a lot of the good discussion comes from. So do please put your questions into the Q&A and we will address those at the end. And we've got one immediately, fantastic, really keen audience, this is what we like to see. So without further ado, I'll hand over to Patrick, who will start us off.
Thanks, Alison. So why are we talking about IR35 again? As Alison said, it's about the changes to the rules in the private sector, which were meant to come in April this year and got delayed a year, so are now due to come in April next year. I'm just going to give a brief reminder of what the changes are. I'll give you an update on recent events, and then just go through briefly the steps you should be taking to prepare for the changes. So in basic terms, when does IR35 apply? So IR35 is there because the revenue accept that they can't deem an employment contract for tax purposes. If the end client has a direct contract with the individual, they can consider whether that individual is an employee for tax, and if so, PAYE and NI applies. But if there's no direct contract between the end client and the individual, the revenue can't treat it as employment without something else, and that's where IR35 steps in. Because if you had nothing else, it would be easy to circumvent PAYE by the individual just setting up their own company, what we call the personal service company, and the PSC contracting with the client. And so what IR35 says is if the individual is providing their services through a PSC, so typically that's a company owned by the contractor or maybe them and their spouse, the individual is providing the services personally, the individual hasn't contracted directly with the client, there's one or more other entities in that chain, so the PSC and sometimes one or more agencies, for example, as well. And then the key point is, if that individual would have been an employee for tax purposes if they had contracted directly with the client, then IR35 applies. So there's that key hypothetical test of saying, if there was that direct contractual relationship, is the individual working like an employee, or are they working like someone who is genuinely self-employed? So under the current rules in the private sector, as it applies at the moment, it's the PSC that has to do that determination to decide whether the individual is working like an employee. And if the answer is yes, and IR35 applies, it's the PSC who has to account for the PAYE and NI. So at the moment, that's a really good position for end user clients because broadly, they don't need to worry about IR35. It's for the contractor and the PSC to worry about it. The difficulty the revenue have with that is they feel a lot of PSCs are just thinking they'll fly under the radar and determining that IR35 doesn't apply when actually, according to the revenue, it should apply. And so the changes due to come in next April will instead put that responsibility to do that determination on the end user client. So it's the end user client that if they're using a contractor who is working for a PSC, they will need to determine whether that individual is working like an employee for tax purposes. And if so, they make that determination, and the person who is paying the PSC, or the entity that is paying the PSC, needs to operate PAYE and NI. So if it's the end user client contracting directly with the PSC, and they determine that they're inside IR35, the individual is working like an employee, the end user client would need to operate PAYE and NI. Whereas if the end user client determines they're inside IR35 and they're contracting with, say, an agency, who is then contracting with the PSC, the agency that contracts with the PSC would need to operate PAYE and NI. The end user client would pass the determination to the agency. And so this is no longer so good for the end user clients because it's putting a burden on them to decide whether IR35 applies. So in terms of some recent developments, well, first of all, key question, will the changes happen at all? You can't take complete confidence in what I say here as someone who was telling everyone they were definitely going to happen April this year, and then obviously they didn't come in. Personally, I think they are very likely to happen in April. It's taken the revenue so long to get to this position, they're really not going to give up easily on it. And a technical difference this time around is the new legislation is actually on the statute books now. So it would take something positive in Parliament to actually change it and bring it off the statute books again, as opposed to actually it needing to be enacted. It's already been enacted and it's there to take effect with April. So I think it's likely to change. I also hear that certainly some agencies who were lobbying hard last time to defer the rules may not have so much of an appetite for that this time and just want to see it in and not have the uncertainty. It's obviously, if it does come in, it's going to be a bit different in that we had a full start earlier this year. Now, some end user clients may not have done much preparation at all, but most probably would have done because it only got deferred around March, soon after it was due to come in. And so for some, it might be a case of just pulling out the preparation that was done earlier this year. For some clients, they went further than just preparing and had actually changed arrangements with contractors and may have left those changes in place, so there's even less to do this year. It will differ for different clients, but the preparation will be a bit different because hopefully a lot of it has been done. In terms of the impact of COVID-19, there's a couple of things to mention with that. One is that one of the points which comes from the changes is often a negotiation with contractors, because if they are going to be assessed inside IR35, that's a less good tax position for them, and the end client might be saying, you just can't work within IR35 because we don't want to engage you like that, and ultimately that could hit the contractor's pocket with the extra tax, and so there are negotiations with the contractor wanting to get paid more. That could be a different environment to have those negotiations as compared to maybe ones that were happening, if they were happening in February, March, before the impact of COVID. And another potential impact that's worth mentioning is one of the points that's relevant to the determination of whether someone's working like an employee is the amount of control that they have over things like how they do the work, where they do the work, when they do the work. Now with COVID, you've got obviously a lot more remote working, and you might have contractors who, whereas earlier this year, say in March, may have been assessed inside IR35, are trying to argue that now they're outside IR35 because of the fact they're working remotely and they have more control over how they're working, just because of the way arrangements have changed because of COVID. Another point just to mention relates to umbrella companies. So these are companies that if an individual isn't using a PSC, they may be employed by an umbrella company, which basically operates the payroll and deals with the PAYE and NI compliance. And then typically the umbrella contracts with an agency who then contracts with the end user client. Due to what I would say was an error in the draft legislation, there has been a concern that umbrella companies were going to be treated as PSCs, which would then mean the person, for example, the agency paying them, would need to operate PAYE, which would, to a large extent, make umbrella companies redundant in terms of their purpose. But the Revenue have recently confirmed that effectively that is an error, that isn't their intention at all, and so they are going to deal with it. They haven't said how they're going to deal with it yet. Hopefully that will be a change to the draft legislation. But either way, they have confirmed that that definitely isn't the case for umbrella companies to be treated as PSCs in all circumstances. Another point the Revenue have confirmed is what I would call an unofficial amnesty. So when the rules were coming in April 2020, the Revenue were concerned that end user clients might be encouraged to make the wrong determinations, so to assess people outside IR35, because the contractor was saying, well, if you assess me inside IR35, that effectively means I've been getting it wrong. All this time I've been doing it myself, and you're exposing me to a lot of historic liability to the Revenue, and the Revenue will come after me for that tax when they say I should have been operating inside IR35. The Revenue don't want those concerns to discourage correct determinations going forward. So they have confirmed again that they don't intend to reopen pre-April 21 periods for contractors other than where they think there's been fraud. So just because a contractor is working the same way and they're assessed outside IR35 when the client does it in April, that doesn't mean the Revenue are going to say, well, aha, that means you must have been getting it wrong for the pre-April period. Please pay us all of that PAYE NI that your PSC should have been paying under the current rules. It's not a new point, but it was something which was changed shortly before the previous implementation in April regarding non-UK clients. So initially when the draft rules were made clear, there wasn't an exemption for non-UK clients. Effectively, if the contractor was working in the UK, IR35 was relevant, even if the client wasn't in the UK. And that wasn't really working in the build-up to April because non-UK companies just weren't engaging with it and weren't going to do the determinations. So it's now changed that it's only clients with a UK connection that have to make an IR35 determination for the contractor. And what that basically means is if the client is either incorporated in the UK or has what's called a permanent establishment in the UK for tax purposes, which is effectively a business presence like a branch. So for example, an office, although it can in certain circumstances constitute an individual who is contracting on behalf of the client in the UK. For example, a salesperson who's entering into contracts with clients in the UK on behalf of the non-UK client. But if the client has no business presence in the UK as a non-UK company, then the fact that they have a contractor working for them in the UK doesn't mean they need to do an IR35 determination. And as a final point, just in terms of update, the Revenue have confirmed given some guidance about rules for liability risk. And this is easiest to explain, if I just bring up this diagram, which you don't need to read the very small writing. So there's obviously a lot of entities in this chain, maybe more than usual. But if we had a situation where the client has made a determination, say they've assessed the individual inside IR35, so the idea is the determination then gets passed down that chain. And so the client, if they've made a determination, taken reasonable care, they've discharged their duty at that point. And then as long as each agency passes the determination down the chain, they've discharged their duty. And then the determination gets to the fee payer at the end of the chain. And as it's inside IR35, they need to account for the PAYE and NI. Let's say the fee payer doesn't account for the PAYE and NI, and the revenue can't get the tax from them. So say they've gone bust. In those circumstances, the legislation says that the revenue can then go after agency one in this diagram, so the first agency in the chain, for the unpaid tax. And if they can't get it from agency one, they can then go after the client. And this is obviously controversial because the client and agency one have done what they were required to do. They're determined inside and they pass the determination down. What the revenue have said in the guidance is that they won't do that to claim from agency one or the client if effectively they aren't at fault in any way. So if it's genuine business failure of the fee payer and there wasn't any particular way the client or the agency one could have known that was likely to happen. Whereas if, for example, it was the client or the agency should have realised that the fee payer didn't intend to pay the tax or was just going to ignore the determination, then the revenue would feel they could get the tax off client or agency one. So what the revenue are trying to do is encourage clients and agencies to be very cautious about their supply chain and to not just think they don't need to worry about who entities are further down the supply chain and to monitor it, which is likely to lead to certainly larger clients using less agencies and umbrella companies to make sure they're comfortable with them. So as a summary of the implications for end user clients of the changes, so we've got the greater risk having to make the determinations. If the determination isn't made before the start date of the contractor's work, it's actually the client that is liable for PAYE if it's inside IR35. So the client has the tax risk unless they make the determination or until they make the determination. The changes will also apply to pre-existing contracts from 6th of April, as well as new contracts entered into after them. So there's obviously the increased admin burden of needing to put the processes in place to be making those determinations. And there's the increased costs and potential increased rates. If IR35 applies, you've got the employer's NI cost. The contractor, without going into the detail of how they're taxed through their PSC, will end up with a higher tax burden, and that cost has got to be borne somewhere. And okay, the starting point may be that it's borne by the contractor. The contractors are going to be arguing for increased rates to at least have some of that cost passed on to the client. And then leading on from that, there's the potential loss of contractors who don't have rates increased as much as they need, are told they're going to be inside IR35 and don't want to work in that way, or might look for another end user client who they think might assess them outside IR35. So just briefly going through what end user clients should be doing to prepare. And as I said, to an extent, you might have gone through these steps already in the lead up to April 2020. So in terms of step one, reviewing your current arrangements. So working out who your contractors are. It's worth taking into account as part of this process, those contractors you contract with as individuals, self-employed. So although IR35 isn't relevant to those because they're not using a PSC, it's still, with those, you have the tax risk already. If the revenue said, well, actually, we think this person is working like an employee, they'd be looking for PAYE and NI from the end user client. So looking at your contractors, which ones use PSCs, and then assessing whether they're likely to be inside or outside of IR35, considering both those that you contract with directly with the PSCs and those that you contract with via agencies who are using PSCs. So that potentially involves finding out from your agencies which contractors are using PSCs. A factor that's relevant to identifying the contractors and whether IR35 applies to them is the fact that IR35 only applies to supplies of labour. And so that's effectively supplies of a person. And where it can be quite difficult with some contracts is to work out whether you're being provided with people and the supply of labour, and IR35 is relevant, or where you're being provided with wider services. For example, if I'm providing legal services to you, I'm a person providing those services, but it's viewed as a wider legal service. So you wouldn't have to be worrying about whether I was engaged through a PSC, for example. But that distinction can be quite difficult. So, for example, if you had an IT company coming in to put in a new IT program for you and supplying a team of people to come into your offices to do that, you typically view that as a wider service because they're responsible for putting in the program. If it doesn't work, they'd have to put it right. So they're providing more than just people. Whereas if you're just having an IT consultant come and sit at a desk and fill in a role for 6 months, that will clearly be the supply of a person. So IR35 is only relevant to labour supplies. And then it's a case of thinking about the test. So that hypothetical test, would the individual have been an employee if you contracted with them directly? And the difficulty with that test is it's not black and white checkbox exercise. You have a number of factors which are relevant to them, and you have to weigh up the factors and decide whether they point more towards employment type or self-employment type. I've got a few of the factors there on that slide, or the main ones. And so many of you will have come across the revenue tool for making that determination, known as CEST, Check Employment Status for Tax. It's not mandatory to use the revenues tool. The tool has got better over the years. It used to be really, really basic. It's more sophisticated now, but it still definitely has its difficulties. And I would say it still is biased in part towards employment. Certainly there are certain scenarios where it gives out an inside IR35 answer, but as an advisor I'm looking and I'm thinking I don't think that's correct. But the revenue do say they stand by it if the answers have been entered into correctly. So if you're making an outside IR35 determination using the tool, it's important to record the background to the answers you've put in, because some of the questions are just yes, no, and if the revenue come along later and are challenging you, you'll be in a much better position if you've got some background to why you answered yes to that question or no for that question, and it'll be much more convincing to the revenue. There are other tools out there. The purpose for using another tool, if we're being honest, is to get more contractors outside IR35, because most of the other tools that are out there will have some situations where they will show outside IR35 where the CEST tool would have said inside. But obviously there is some risk involved in that, because effectively then you're taking a view that is different to what the CEST tool takes. And so there's certainly no guarantee that the revenue wouldn't challenge that determination in the future. Once you've assessed which of your contractors you think are going to be inside IR35, you've then got to consider your approach you're going to take with them. So are you going to terminate existing contracts? How are you going to engage them going forward? Are you going to say to continue to engage them inside IR35 and operate with PAYE? That's not easy from an admin perspective. Or are you going to tell them they'll have to go through an agency or umbrella company? and who's going to bear the additional costs? Will you increase rates, or will you hold firm to just say the rate will stay the same? And a lot of that is weighing up tax risk against commercial impact. So you may well have some borderline contractors that it's arguable whether they're inside or outside. Are you going to take a view that they're outside and accept there's a bit of a risk of challenge because it's so important commercially to keep those people? Or are you going to put tax risk at the very top and say we're just not taking any tax risk? And some end user clients have even just said we're not using PSCs at all. Step 3, education and communication. So there's 3 elements to that. There's your internal staff, so ensuring they're comfortable with what they're doing as part of the process and the determinations, and everyone knows what they're doing, who's doing what, and are on board with the processes and the decisions that are taken in terms of how to deal with it. You've then obviously got your liaising with contractors, making sure they understand whether they're going to be inside or outside, your approach to that, and agreeing how to operate with them going forward. And you've got communications with your agencies and suppliers. They may well be communicating with you as well, because they'll want to be clear about how you're dealing with the contractors that you engage through them. And then finally, step 4, developing a compliance process. So you want to have going forward a very clear process for making the determinations on time before people start, communicating those determinations to the contractors and the agencies. You'll need to be doing that in the run-up to April for your existing contractors who are going to be working post-April, and then also have the process in place for any new contractors post-April. And it's obviously important to be clear who is doing what as part of that process. And keeping written records, as I was mentioning, is very important in terms of if you get looked at by the revenue, puts you in such a better position if you've got clear written records, and to setting out what your process is and then how you've made your determination in each case for each contractor. And then as a final point, it's important to have a periodic review of your determinations. I'd say somewhere between 6 months and a year is probably the most likely on average, because as we know, the way contractors work can change over time. So whereas you may have determined them outside initially, things may have changed in terms of how they work, and then 6 months later, a year later, they could be working completely differently and could be a lot more like an employee. And it wouldn't matter to the revenue that you made your determination at the start. They'd come in and say, well, what is the position now? That means the determination is wrong as of now, you've got it wrong. So that's all I was going to say. I'll pass over to Alison to say a bit about the employment status and relationship with IR35.
Thanks, Patrick. About it, there's a few probably that I wanted to highlight that come up quite is that as things stand at present, if somebody is determined to be inside IR35 for tax purposes, that doesn't necessarily mean that they are an employee or worker for employment purposes. So the test, whilst very similar for employment and tax in terms of employment status, it isn't the same. And therefore, one doesn't necessarily lead to another. And I know certainly a number of end user clients who have been concerned that they need to change their contracts in terms of putting people on employment contracts, when that's not necessarily the case. Those two things at the moment don't follow. One of the things, however, is that the government is considering bringing the two things together. And I think that's it was part of the Taylor review. It was mentioned, I think that was 2019. Nothing really has advanced in relation to that yet. I think the government's probably had one or two other things on its mind at the moment. But trying to align the tax and employment law is not going to be easy. At the moment, it is a lot easier for somebody to be found to be employed for tax purposes compared to how it is for employment purposes. The test is much easier from a tax point of view. And therefore, it does concern me that if they were to try to align these two things, that what you would actually end up with is a situation where, from an employment perspective, you end up with more people falling into being employed than is currently the case. So that is certainly one to watch. The other brief thing that I will mention is the agency worker regulations. So under the agency worker regulations, there is a provision in there to say that if the end user client is a client of the person providing the services or their PSC, then they won't fall into the AWR. So it's not quite as straightforward as saying if you're through a PSC, you're outside the AWR. They wanted it slightly broader than that to stop abuse of the legislation. But if you are going through this process and determine that somebody is in scope for IR35 purposes, then it is also important just to reassess whether the AWR is applicable in a situation where the individual is being supplied via an agency, via a third party. Because if they are in for tax purposes, it doesn't necessarily mean it follows that they are in for the agency worker regulations, but it does increase the likelihood. That is something just to be mindful of, because that is something that may need to be revisited. Right, I'll now pass over to Daniel, who's going to talk to us a little bit more about the kind of practical implications of all of this. Thanks, Daniel.
Thank you, Alison. Everybody. I thought it would be useful in my part here just to talk a little bit about the behaviours that we've seen from clients in that sort of dry run that we had back in March, just before the postponement. Have a think about it from a sort of hirer perspective, from a contractor perspective, and from a recruitment business perspective. And I'll just give people a sense, if you've not already executed that plan, what's on the horizon for Q1 next year. So just sort of working through those observations, I think it's fair to say that from a hirer perspective, a lot of the decisions that are being made seem to be dictated very much around risk. And as Patrick's slides pointed out, there's certainly potential for risk to pass back up a supply chain here under this legislation. So we have seen and continue to see quite a large number of hirers making a decision not to blanket assess people inside, but a slight subtle variation to that, where they'll actually made a decision not to engage with PSE contractors moving forward. We particularly saw that within the financial sector, and that allows the client to sort of sidestep this reasonable care argument and that whole administrative piece of work of doing assessments by saying, commercially, we're just not going to engage a contractor who wants to operate via a PSC, and that then forces the engagement to either look via an umbrella company or potentially PAYE. So that's certainly one option that hirers have been looking to take. I think also, as Patrick referenced, we've seen a number of examples where hirers are paying attention to the supply chain a lot more, wanting to make sure that particular payroll companies are being used where they've got a strong reputation for compliance, trading history, strong balance sheet, to ensure that if that person is going to be responsible for deducting tax, or that business is going to be responsible for deducting tax, so they're not going to fail in the short term, because clearly, again, there could be scenarios where that debt transfer passes back up to the hirer. I think one thing that is absolutely key to this is, the first part is when you're looking at assessments, is looking at IR35 and assessing if contractors are operating in or out. But probably equal, if not more fundamental to that whole conversation, is actually how business critical these contractors are to the function. And it may well be a hirer really making a decision between sort of how much they're happy on a scale of around financial cost alongside sort of compliance risk, as to whether or not they want to make decisions which are least risky, which would be not to make any assessments, perhaps just to say we're not going to engage contractors in limited companies moving forward. But the knock-on implications of that are potentially looking at increasing their costs, as Patrick was touching on there. And we've seen probably, I would say, roughly 5-6% of contractors who are deemed business critical within a population being given pay rate increases to ensure that their sort of net take home remains similar to what they're on today, and the hirer can be assured that that contractor's, staying on site. Where that business critical assessment's being made, and decision might be that that person could be easily replaced, or even perhaps the hirers on reflection wondering if they still need to retain that contractor, then sometimes hirers will make a decision to maybe increase rates partially to perhaps cover the employer's national insurance piece, or not make any increase, and actually the contractor feels that burden. I think what we've also seen around the impact of COVID is also probably not for every hirer, but as a general trend, a reduction in contractor numbers from where the contractor numbers were back in March of this year. So clearly, hirers have been making decisions just on the number of contractors they've engaged over time, and it may well be that the population of contractors is smaller this time around than previously. I think when you step away from the larger hirers and into that more SME part of the market, then certainly still, surprisingly, given the level of commentary around this topic, still a lot of an awareness about the implications. We should bear in mind that for small companies there is an exemption under this new regime. Not to say that IR35 doesn't apply, but if a hirer is a small business, then the old regime applies where the contractor makes a decision and the contractor carries the risk. But certainly in that medium enterprise space, I think there's still a bit of education to be done, which hopefully will be certainly the recruitment business is helping out a lot there to make sure those businesses understand the implications. From a contractor perspective, they'll shop around a lot to look at the best offering for them. If they're being told they're going to be deemed inside IR35, then they'll continue to consider what the payroll options are, and they're often focusing on the sort of net take-home pay. That can lead to some engagement or some interest in some non-compliant payroll arrangements, which I'll touch on at the back end of this slide deck, something that everyone should be looking at avoiding in their supply chain, because it does present risk. But unfortunately, these providers are very good at advertising and marketing their schemes as tax efficient or signed off by HMRC, which would never be the case. So contractors should be encouraged to avoid going down those routes, and where possible, a hirer and the recruitment business should be looking at trying to put a preferred supplier list in place of payroll businesses to stop that from happening. The contractors will clearly be anxious to know what their determination status is likely to be. I think last year we saw most of those decisions starting to come out around about January. In some instances, but some were delayed until sort of closer to the deadline, which meant operationally that became quite challenging to move through, particularly for the recruiters to look at renegotiating rates, ending contracts and starting new ones. So I think where possible, we would all encourage hirers to be looking at, if we're going to make determinations, to be doing that round about now and start communicating those decisions out, so contractors can be assured what the position is and they can plan for what it's going to look like for next year. I think from a recruiter perspective, again touching on Patrick's point around risk, recruiters will be keen to make sure where they are engaging payroll businesses to support workers deemed inside, and that they are financially secure, and they are in a strong position to avoid any of that debt transfer, particularly where that business might be looking at acting as the fee payer and continuing to process payments to the limited company still for the contractor, sometimes referred to as a deemed payment model. But also agencies will very much be looking at trying to offer a range of different payroll options. So most will have an umbrella PSL in place already, perhaps looking at reviewing that list. Some may offer PAYE. There's another payroll model which I'll touch on shortly called PEO, which stands for Professional Employment Organisation, which is very similar to umbrella but much more simple from a contractor perspective and easier to understand. Patrick, if you could jump on to the next slide, please. So moving on to talk about those different payroll options. Well, clearly, if the worker's deemed outside, they could continue to be paid through their limited company as normal. If they're deemed inside, then there is this ability for payroll businesses like Giant to be able to offer a service which is a deemed a service for tax, where the payroll provider would still engage with the limited company, but make sure the right taxes are deducted and paid off to HMRC, therefore acting as the fee payer, and pay the net that's left over to the contractor's business bank account. You'll find some contractors will be interested in doing that because perhaps they have other assignments outside of IR35, which they wish to continue to get paid into the limited company. So just for ease, they want everything paid into the same account. That's certainly one option. I think the majority of the market will certainly be looking at taking advantage of the umbrella model. It's established out there. Probably our observations would be 70% of workers deemed inside will probably fall into umbrella models moving forward, with the balance either going PAYE with a recruiter or going down that deemed route. The nice part with the umbrella companies that, to Alison's point, while somebody may be being taxed like an employee, that doesn't necessarily mean they get the employment rights of an employee, but an umbrella company, if they're using an employment contract, will bring that into play. So through the umbrella arrangement, the contractor will get employment rights as well as paying the tax, which would appear equitable. And then finally, just this PEO model that I've mentioned, it stands for Professional Employment Organisation. I think we've seen many more, this acronym's been mentioned in the market. And what a PEO is basically is a company that will employ the workers, so very similar to an umbrella company, but the way that the invoicing works around the employment costs is different. And so the wage slip format for a contractor is a simple wage slip, which shows them clearly the tax for NI and PAYE, whereas an umbrella wage slip sometimes can be a little bit more complex, because on there it would also show the employment costs that are being deducted by the contractor with the umbrella, as well as their margin. So it won't be suitable for everybody, but there'll be certain pockets of business where that PE model will be used, and it fits quite nicely into that good work plan that Alison mentioned to give transparency to workers on the pay rate. Because on the PEO, you would tell the worker the PAYE rate that they were on from the beginning, whereas through an umbrella arrangement, the umbrella company still receives that limited company rate that used to be paid through to the contractor's PSC, so it can be viewed as a bit more transparent. If you could skip on to the next slide, Patrick. So just finally from me, in terms of having your wits about you, if you're looking at engaging payroll businesses, there is the good, the bad and the ugly in my sector. The good providers, the only difference really should be the margin that's being charged. All tax should be deducted as per HMRC guidelines. Where it moves into bad and ugly territory is where you have loan type arrangements or offshore arrangements that try and disguise part of that remuneration as something other than salary, which can lead to an increased net take home for the worker, up to sort of 90–95% take home. But HMRC have been doing a lot of activity in chasing up contractors engaged in these sorts of arrangements. So where possible, you should be looking at trying to pick from the good guys, and I would always recommend FCSA, the Freelancer Contractor Services Association, as a good starting point. There's a trade body of umbrella companies who are regularly audited by accountants such as EY to make sure that all the right processes are being followed. So yeah, just make sure you've got good supply chain compliance and due diligence when you're seeing payroll providers in that supply chain. Thank you.
Thanks, Daniel. Q&A section of it, just as a reminder, if anyone's got Q&As, if you put them into the Q&A box that appears on your screen. I think this first one's for you, Patrick. There's definite common themes amongst the questions. And we've had a number of questions about overseas people or internationally placed people, both from a perspective of when's that connection with the UK? So a scenario where you've got an individual who is doing effectively the same work as they would do if they were in the UK but happen to be living overseas, or a scenario where you've got a UK company who has interest in, say, another jurisdiction, let's pick Spain, and that person is engaged to do the work in Spain within the Spanish market, but it is for a UK company. So could you just give some clarity about how IR35 will affect those two different scenarios?
Yeah, of course. So there are two things in terms of the UK connection that need to be in place. The first is what I was talking about earlier. The client needs to either be a UK company or have a UK business presence, permanent establishment. But the second is also that if the individual had been an employee, they would have needed to have been subject to UK tax in the first place, by IR35 to apply. So you're saying, if we had employed this individual, would we have to be worrying about UK tax? And the broad position with that is that UK tax applies to someone working in the UK, but subject to a couple of exceptions, it doesn't apply to someone working outside the UK. So if you are engaging, or a UK company is engaging a contractor in Spain or wherever it is, it doesn't matter that they are UK. If a contractor is resident in Spain and working in Spain, doesn't work in the UK, so the contractor has no UK connection other than the fact they're working for a UK company, IR35 isn't relevant. The same way that UK tax wouldn't be relevant if that UK company were engaging an employee in Spain. The only caution I'd give to that is in the same way as with employees, if that person is still UK tax resident, then IR35 could apply. For example, it might be an individual who has lived in the UK but has gone to Spain to do a particular assignment for 6 months before coming back to the UK, then IR35 could apply them because they are UK tax resident. That is the UK connection. So as I say, very, very simple. If it's just an individual working outside, clearly always been outside the UK, you don't need to worry about IR35.
That's great. Thanks, Patrick. We've also had a few questions through around umbrellas and just asking what's happening with umbrellas and how does IR35 apply in that scenario. So particular question, what's happening surrounding the confusion, applying to umbrella companies, meaning that the agency is the fee payer.
So I'll take that in a kind of technical sense. So as I said earlier, there has been confusion. It's very clear that the revenue don't intend all umbrellas to be treated as personal service companies. So in your normal situation with a usual umbrella, it would be the umbrella who would be accounting for PAYE and NI, and IR35 wouldn't be in point. The one caveat I'd say to that is there are some contractors who have been setting up their own umbrella companies, for example, simply because they don't want to pay a fee to an umbrella company. And obviously, if that company, they're calling it an umbrella, but if the contractors own that company, it is a PSC, because that's the test for seeing whether it's a PSC. Does the contractor have that shareholding in the company? And I had one scenario with a client where the contractor was saying, well, no, it's an umbrella company, I don't own shares in it. But then when you went on Companies House, you saw that his son had the shares. And although he'd assured the client that he had no interest in that company, actually someone connected with him had the shareholding, which meant it was going to be treated as his PSC, which meant IR35 applied and the client needed to do the determination. But in terms of your kind of standard umbrellas, they won't be treated as personal service companies.
Yeah, I was just going to add to that, Patrick. I think for collecting the tax purposes, umbrellas have a big role to play on behalf of HMRC in collecting that tax. I think we're all in the industry assured that HMRC will fix the issue around the drafting. And I think also just earlier in Alison's question, how does IR35 apply to umbrella companies? Well, clearly, if it is a compliant, vanilla style umbrella offering, then IR35 should always have applied because those workers are engaged on an employed basis, and that's what the umbrella's there to do, to deduct those taxes that are due under IR35. So I think we're not expecting in the industry huge last minute panics around that legislation. I think HMRC have got a vested interest in fixing it because the umbrellas will play a huge role in collecting that tax on their behalf.
Okay, thank you. Just jumping back slightly to the international question, just someone's asked for some clarification around that, is where the end company is a non-UK but is using a contractor inside the UK through a PSC, would IR35 apply?
Yeah, so the answer is no. If the end user client is a non-UK company or entity and doesn't have a business presence in the UK, the fact that they are using the contractor in the UK with a PSC in the UK doesn't mean that IR35 applies. It doesn't mean that the client has to do the determination. In that case, it's the PSC that has to do the determination as per the current rules. It's only an end user client who is either a UK company or has a UK presence that needs to operate the rules, regardless of even if the contractor is working in the UK.
Okay, thank you. Next one, a couple of people have asked the same question, is how does IR35 differ when you contractor with their own company versus somebody who is self-employed?
So just to be clear, what I interpret that as is what's the difference between someone who the client has just contracted with as an individual as compared to where the client has contracted with a PSC or an agency who has then contracted with the PSC. And as I said earlier, if you've contracted directly with the individual, IR35 doesn't apply because it's always been the case you have to consider is that individual an employee for tax purposes. But in terms of the test is exactly the same. So the IR35 hypothetical test that says if we had contracted directly with the individual, would they have been an employee? That's the same test as you should be applying for anyone you contract directly with as an individual. And CEST, the revenue tool, actually applies for those situations as well. Now, in the past, I think it's interesting. It's almost like clients have focused so much on IR35, they've sometimes forgetting the risk that's been an ongoing risk for them, which has been those individuals they contract with directly, because that's a risk that if the client is getting it wrong, it doesn't just start from next April. It's a risk that's been there from when that individual's been engaged, because if the revenue say they're working like an employee under the test, PAYE applied from whenever they were engaged, which is why I think it's quite helpful in terms of going through the IR35 preparation process to bring those directly engaged individuals within that process. So you're assessing those as well and making sure you've got everything correct for all your contractors.
Thank you. Again, a couple of people asking a similar question around who's undertaking the assessment and then who's liable if it's not right, and have effectively, if it's a business carrying out that assessment because they're best placed to do so, haven't they got a vested interest in terms of that result?
I'll ask technically, and then I'm sure that Dan has got some thoughts on the practical side of it. It's the client that has to make the determination. As long as they take reasonable care, they've discharged their duty. So even if the client gets it wrong, if they've taken reasonable care, they still don't have a liability, which is something which has gone down quite badly with agencies, that particular point, because if the client takes reasonable care but says it's outside IR35 and the revenue say later, well, we think it's inside, but we think it was a borderline one, so client, you still took reasonable care, but that means fee payer, let's say agency, who is paying the PSC, you should have accounted for PAYE, even though you just received a determination that told you it was outside IR35 and followed it, which is obviously quite a difficult position for agencies to be in, which means agencies are very interested in how clients are doing those determinations, because they could be exposed if they're incorrect outside determinations. But then practically, you've always also got the point about clients and agencies working together, because they might know different aspects about how the individual's working, and it's best if it's a combined approach to doing the determination. But Dan, I'm sure you've got thoughts on that.
Yeah, no, you're quite right, Patrick. It can put the agency into a tricky predicament there. So I think what we see practically happening quite a lot is that the agencies will be insistent that the assessment is being done by someone who is senior within the client, so HR director or something of the equivalent as a starter for 10. I think we also see sometimes duplication of assessment, so you'll see assessed being used as a sort of base test, and then where people are potentially being shown to be inside with CEST, but there's a feeling that actually we think that work could be outside, then they'll look to go to market with one of the other commercially available assessment tools and assess via those arrangements as well, which then obviously brings in mutuality of obligation and other factors that CEST's been criticised for omitting. There's also quite a lot of activity in the market around insurance as well. So some of these alternative IR35 assessment tools will then also go on to say if they provide a decision which is outside, they can then provide an insurance policy which will insure the fee payer, i.e. the agency, if HMRC are to come along and challenge that assessment. You know, how sturdy or robust those policies are, we won't know until probably further down the line. I think certainly most recruiters will not just take a decision blindly. They'll look to ensure they understand who's made that, are they senior, do they understand the detail, and if they can back it off with a second assessment and perhaps utilising the insurance, then they'll seem to get a level of comfort. But it is definitely a tricky one.
Yeah, I would agree with that. So I'm going to squeeze in one last question, which is a very practical one, which is, if after assessing an individual and they're outside IR35, can the end user then provide them with equipment such as a laptop if they're working with sensitive data or are nervous about them having third party attaching to their network, or will this affect the outside determination?
I'll answer that one. It's a relevant factor. As I was saying earlier, there are a number of factors that you're weighing up, and one of them is who provides the equipment. And certainly it looks more self-employment like if a contractor is providing their own equipment. But with many clients, there is a need for the contractors to be using the client's laptop for confidentiality purposes and security purposes. And in my view, that wouldn't be a major factor in that scenario because that is clearly a business need. It's just one of the factors to weigh up. And so I suppose it's a very small pointer towards employment, but only a very small one. If a contractor was using a lot of their own equipment, that can be a very large pointer towards self-employment. Most contractors we come across where you're just talking about laptop and mobile phone, it's not a huge pointer either way, and the other pointers tend to be more important.
That's great. Thanks, Patrick. So we're just coming up to half past now. I have had a question just asking if the slides will be available. Yes, the session is being recorded and the slides will be available sent to you after this session. So hopefully they have been of use. So I'll just wrap up by saying thank you so much for everybody joining us this afternoon. I hope that we've managed to answer your questions that you have. If anybody does have any additional questions, then do feel free to contact any of the three of us. And I hope you have a wonderful rest of your day. Thank you very much.